Okay, hello everyone. Thanks for joining us. Jim, that was very informative. I appreciate that, especially since we are having some issues filing some of those things. Government forms are usually made to be difficult, and as difficult as possible, it seems like sometimes. Anyway, so I'm a lawyer. This is part 2. We did a bit of employers' best practices for BC last week, and this is kind of a getting back to work continuation of employers' best practices in BC. So it is BC, as I mentioned last week. Legislation in every province is a little different, very similar, but different, and I act in BC, so that's what I'm going to be dealing with. I do act for employers, I act for employees. Jim's a certified fraud examiner, I'm also a certified fraud examiner. And so I've met Jim, I've known Jim for quite a few years, and we've worked together. And in fact, when we started, it's our 10-year anniversary today, or this year, as you can see from our logo. And we worked in the back of Fernandez Young's office. And so they're always going to be part of our history, and certainly we do appreciate that. What we're going to be going through today is best practices, not legal advice. Okay, so you kind of get what you pay for. And when you see these things on the news and you see blogs, and you should always think, is this something I can take to the bank? And I will tell you that we've put some effort into putting this together, and I think it's good general overview, but it's not specific legal advice. If you get down to a decision-making situation, you probably need to hire a professional, and you should do that. And that's kind of what professionals are there for. And then you can depend on what they say specifically or not specifically. Or sorry, you could depend on what they say specifically in case of your situation. This is not about unions, so unions is kind of a different beast. We do that as well, but it's not something we're going to talk about too much. Or federal employees, or what they call federal work, so things in banks and at airports. This is just kind of employers in BC generally. So we'll have questions at the end, and I'll go through kind of what we're going to talk about a bit today. But with questions, each question, decent question, we'll give away one of our hot off the presses USB 16 gigs DLG stamped USBs. So I'll send that to you, and we'll even put the presentations on it for if you like. So feel free to ask questions, and hopefully that'll get some decent questions. With regards to today, I invite you to kind of have a bit of maybe what we call maybe a drinking game. I know it's 12:30, but you might be watching this at a YouTube. So, or you don't have to drink alcohol, or, there's always cannabis out there, that's legal as well, but you can just have coffee or water. But every time I say the word unprecedented, I would hope you have a bit of a drink. Hopefully you don't get hammered or anything, but let's try and make it interesting. I've watched a lot of presentations from a lot of levels of government, and man, they say unprecedented quite a bit. So I'm going to see if I can not say it as much, but say it enough to make this interesting. Things change every day. Jim's talking about every week he's going through some things, but I'll tell you, things have never changed so much. And in fact, I would say clearly it's unprecedented. And I mean that seriously, in that things like the Employment Standards Act, it changes maybe once every 4 or 5 years. It's changed 3 days ago, and I'll talk a bit about that. It changed last week, and I talked a bit about my presentation. So you can go through this presentation, and I think it'll assist you, but really you need to get up to date professionals to assist you, because it's a very unprecedented time. So let me just talk about best practices. So this is what we did last week, and we're going to do this a little bit this week. I'm just going to quickly go through, so I'm not going to do it again. What we talked about, and I think we gave you some best practices on dealing with employees. Keep them if you can, and work with your employees. Modify the job as little as you can, and if you do modify it, put those modifications in writing. If you have to let them go, do so with agreement to bring them back. And if you were there last week, you heard that this is unprecedented Employment Standards Act amendment that allows for temporary layoff to deal with COVID-19. So it was very, very unique. But if you do deal with that, then make sure it's clear when you're going to bring them back, what are the terms of bringing them back. And if you don't bring them back, then you have severance. And we talked a bit about that last week as well. And I think the biggest thing I wanted everybody to take from last week was have an employment contract with every employee. Now, I didn't mention this, and I want to make this clear. You should have an employment contract. You should have that drafted by a lawyer, obviously. Now, if you have an employee that's been there for a while, you can't just impose an employment contract on them. You've already made in a contract, and we talked again about this last week. Those were oral terms. If you want to now impose more terms on them, you have to give them something for that. So if you want to now take an employment contract and then basically tell your employees they have to have it, and we talked a bit last week why it's so good for you to do that. Some of the reasons you can save lots of money, you should probably engage a lawyer of how the best way to do that, okay? So today, we're going to talk about bringing back employees, keeping the workplace safe. And I mean this, let me be clear, I'm a lawyer. I'm talking about the legal ramifications. I'm not a doctor. I'm not an expert on workplace safety. I'm going to talk to you about what it looks like the law says are best practices, and if you follow those best practices, you decrease the potential risk. Privacy issues for employees, possible liability issues when it comes to the public and your employees. Now, let's start off. So bringing back employees. So this new amendment under Employment Standards Act, it basically, as we talked about last week, is you can't temporarily lay people off unless there's certain criteria. And the criteria were, with regards to COVID-19, 5 points. We went through that. We won't go through that again. And it's leave without pay. So one thing that's happened 3 days ago is they took that temporary leave from 13 weeks to 16 weeks, over a 20-week period. So that's important because it can't be forever. Now, let's assume everybody kind of got started around the same time. You're probably at the 5 or 6 week point, maybe 4 weeks, but keep that in mind. This can't go on forever. This has to be acted upon at a minimum within 16 weeks. Now, another thing I think is important for you to know is if you bring someone back and you give them less than 50% of their hours or their work, that would count as another week. So what I mean by that is, let's say you brought someone back after 6 weeks of them not being in the office, you haven't paid them, you bring them back, but you only say to them, hey, I can't give you 40 hours a week, I can give you 5. That would count as another week under the layoff under employment standards. Okay, so you must keep that in mind. Common law termination, remember, if you don't bring them back, that's basically if you don't bring them back, either when the government says you should bring them back or at all, that triggers wrongful dismissal without cause, and that triggers severance, and that triggers money, okay? And again, we talked a bit about last week, is there's limitation periods, and that's all in that other presentation. But let's go through an example. So we talked about how to bring people back and when to bring them back. And actually, I'm going to go through the example, I think, with the quick tip. And so the quick tip is bring employees back after the government says it's okay. Now, you can do it before, but you'll see that there's a bunch of issues with that. We're going to talk a bit further in the presentation. But here's the real difficult part is, which government? You have a municipal government. If you live in the city of Vancouver, that's Vancouver. It could be Port Moody. You have a provincial government. So we see Dr. Bonnie Henry on TV. She's the provincial government, or represents provincial government, just as John Horgan does. And we, as Jim was talking about, we also have Prime Minister, that's the federal government. All levels of government have some say, or may have some say, in when you should bring people back and what the criteria should be when you bring them back. And that's important. So I'll give you an example. Let's say you're an electrical company. And so an electrical company is under provincial guidelines. So at some point, the government says, provincial government says, come back. Okay, well, you've got to follow those guidelines, what the terms are and when. Let's say you're in the city of Vancouver, and part of the job as electrical contractors, you have to go into the city of Vancouver's office. You go into the city of Vancouver's office, you have to follow their criteria. Or let's say you have to get a permit, and how you get that permit, how you use that permit, maybe on site or whatnot. Again, that's a municipal issue. If you have to fly somewhere, let's say you're doing a rural job and you have to fly somewhere, then you're under the federal guidelines. Let's say you have to go to a supplier, and that supplier, they have their own guidelines. You have to be cognizant of those guidelines, and you have to So when you bring an employee back, you can't just bring them back. You should, first instance, only bring them back after the government or the powers that be, depends what situation it is, say it's okay for you to do that, okay? That's important. And you should be aware of all those levels of government. Now, here's something I thought was interesting, because what do you do if some people don't want to come back to work? And I think as an employer, I've kind of dealt with this a little bit. I've certainly discussed issues with employees, and there's concerns. There's concerns. Some people have to take transit. Some people are concerned of the people they work with. They don't, they kind of had a very high sense of anxiety built up under this situation. So what if somebody doesn't want to come back to work? Government said it's time. You're ready. They don't want to come back. Well, this is a little bit beyond legal, but this is what I would say is a decent legal framework to protect you as an employer. Okay, so first of all, discuss with them why they come back. And this is, again, goes to best practices. What's their concern? Ask them, why are they concerned? What can you do about those concerns? So we have some individuals, we've been open smaller hours this whole time, and we've done a bunch of different things. One of them was, if you're taking transit, you weren't coming into work. Some people had the ability to have a car. Some people had the ability to be driven. Some people, like myself, walk into work. But that was a concern, and we dealt with it, and we thought it was a reasonable concern. And I think now we're going to have to deal with it when people come back. What do we do now? Well, we're going to do what I've suggested here. We're going to have a Zoom meeting on Monday and talk to this staff and say, hey, what do you guys think? What are your concerns? What can we do to alleviate those concerns? So educate them as to real concerns. So now we have social distancing. We have very low incidences. We have masks that seem like in some instances are going to be mandatory. So talk to them. What are you concerned about? This is a big one. I'm going to talk a bit about this a bit more, but what unique situation may make them more vulnerable? They may not be vulnerable. They may feel, as many of us do, just anxiety. That's fine, but you should know. So there could be some vulnerable situations. They could have health problems. They could be, this one you probably shouldn't have to ask, but maybe they could be 70, 80 years old. There could be a reason that makes them specifically very concerned. Ask them about them. Have that conversation. Now, once you know, see if you can accommodate them. Now, there's human rights legislation. We talked a bit about this last week in regards to discriminating. You can't discriminate about someone. Well, human rights and BC Human Rights Code is what we have in BC, but every province has one, and there's federal ones. That legislation also creates a duty for an employer to accommodate medical conditions. Okay, and that's a high standard. So you need to know. If you don't know, you can't accommodate, but let's say you do find out that someone has a condition. What can you do to accommodate them? So the human rights legislation says you have to try. Now and I won't deal with, and I have to say, and all joking aside, but this is very unprecedented. We don't have a situation where we have a physical virus, and we have I think one of the big issues is going to be is the mental issues that come from that. And how does that interplay with what an employer can and can't expect from their employees? We don't know. We don't know. Some people are going to have very serious mental issues about leaving their house. And where does an employer-employee relationship fall in there? That's going to be difficult, but at least you should know. Best practices you should know. The truth is, you may have to make some hard decisions to demand them to come in. We're going to talk a bit about that, but I suggest to you, you seek professional assistance before you make that call. My suggestion would be it should be a lawyer. You might have an HR department. They may be well versed in this, but you might have to go to the end of the road. And we talked a bit about this last week, but if you say your job is to come in and we can't accommodate you, and you better be right. It better not just be we don't want to accommodate you. It's uncomfortable to accommodate you. You might have to ask for a doctor's note. You may have to understand why. If it's a mental issue, I can't really say it's too specific to deal with on a presentation. But eventually, if you do everything you can do and everything you're supposed to do as an employer and they still won't come in, you might have to say to them, hey, you're abandoning your job. you know, you just not coming in. There's no combination that you are required or we're required to make, or that we can make. And if you don't come in, you've abandoned your job. They quit. That's going to happen. I don't know what that looks like. And just so that, you know, you didn't have to wait too long for your next sip. It's unprecedented. We don't know what that looks like in front of the courts. We don't know what the courts are going to say about that. We don't know where that line is going to be. So my suggestion is best practices. You want to reach over. You want to do as much as you can. You want to be able to show a court, wow, we did everything we could or reasonably could, and we followed these guidelines. But that's going to be a unique situation. So the quick tip, do everything you can before letting somebody go. And let me be clear, and this should be hopefully somewhat regular procedure. Document what you've done. Document what they've said. Do that in a way, you know, give them time to think about what you've said. Hey, you know what, if you don't come in, we've explored all our options. We're going to have to take the position that you're quitting. Give them an opportunity to fix that. They might say, you know what, I see your point and I'm going to come in. Give them the opportunity to work with you. You do not want to have to deal with this, because if you're wrong, and this is why you want to hire a professional, because if they're wrong, they have insurance, they have standards, and then you can lean on them. That's what you pay them for. But if you're wrong, you're going to have to deal with it yourself. And you know, if something hasn't been, if there's no history of how the courts have dealt with something specific, you're taking some risk. And maybe the best thing to do is hire a professional to take that risk for you. So workplace safety. So what is safe? Well, that's the question. And I've been listening and watching other lawyers and other professionals and just people out there in the world. And they've said a couple things. And one was, do you have to prove that it's a safe environment or a safe workplace, or does the employee have to prove it's unsafe? Well, I certainly have, you know, if you guys want to weigh in about, and Eli, if anybody says what they think, this is an interesting question. I think, you know, and again, you know, again, all joking aside, it's unprecedented. We don't know, because but what lawyers do know is what's happened before. We have a common law system. So we can take a situation and say, look, let's extrapolate that situation and the ideas behind that to what the courts have said, and maybe we can give some guidelines. And I think that's reasonable. So, and then there's also the practical aspect of it. So if you have to prove your workplace is safe, you know, and so WorkSafe BC, and just so everybody, I'm sure you're all aware of WorkSafe BC. That is an organization that employees all employers have to be members of in BC, and all employees are protected by in BC. And it creates this regime where you can't do anything but sue, or sorry, WorkSafe complaints. You can't sue someone if you're an employee and they slip and fall and hurt themselves while they're working as an employee. They can't sue you. They go through WorkSafe, which is a good, and I guess sometimes it's a bad thing as well. So that's a legislation you should be aware of. Legislation you probably are aware of. Legislation or an organization you pay now. And if you ever had somebody hurt, you know, I remember we had an employee that opened a door and hit herself in the head with the door. And she actually kind of had a bit of a situation and went to WorkSafe, and we filled out the form, and, you know, it was nothing that came of it. But WorkSafe investigated and wanted to make sure we weren't hitting our employees with doors, and they were satisfied we weren't. You know, this is a thing that you just have to deal with. Now, imagine if you had to prove your, you know, under COVID-19 regulations or COVID-19 issues, how would you even prove that it was safe? I don't think you could, because nothing is safe, 100% safe. You know, getting to work is dangerous. And frankly, COVID-19 has made it much more concerning, but it's always been somewhat dangerous. You know, you can get hit by a car, you can slip and fall, a whole bunch of things can happen to you. Workplaces can't be guaranteed to be 100% safe. They can't be locked down. You know, we have to interact with each other. We have to interact with dangerous things, some more than others. As a lawyer, I don't really have to interact with too many dangerous things. But, you know, if you're working electricity, your day, you probably, you know, if you're not cautious, things can happen. Certain chemicals, things like that. But with COVID-19, I just think it's unrealistic to have every employer shut down until a WorkSafe can come and show that it's safe. So I think the answer is clear. With regards to WorkSafe, the employee has to show it's unsafe. Okay. And what does that mean? Well, that means there's precautions the government have said, and you're not following them. Now, that could happen from a couple of different ways. An employee could say, I feel unsafe, and WorkSafe might say, well, tell me about this space. And, well, they don't make us they make us work very close to each other. They don't make us wear masks. They make me come in even though I felt sick or I had symptoms. Those things, I think WorkSafe would say, nope, that's not safe, and you probably would risk being shut down if somebody complained. It could be that somebody gets COVID-19 from your employment while they're working with you. And WorkSafe's like, I want to know, or government, but let's say it's WorkSafe, they want to know, what are you doing to ensure this didn't happen? Let's say one person gets sick. Let's say 10 people get sick, like those meat packing places. WorkSafe, although that was one of them is Alberta, but let's say the chicken processing plant. WorkSafe is in there and being involved, or some level of government is being involved because it's their job to keep employees safe. So what can you do as an employer? Do what government suggests, okay? We've heard yesterday that there's some suggestions about what to do, who's going to open up. Ask them questions. Find out what criteria is there. And again, remember, it's the federal government, which is not giving much direction on this level because they've given it to provinces, but the provincial government, the city that you're involved with might be giving instructions. If you're an electrician, it might be, there's an organization that makes sure that, electricians are safe. If they have COVID-19 regulations, follow them. Keep records. Because what's going to happen is if somebody does knock on your door and say, hey, we have a complaint or concern that this is an unsafe workplace, you're going to have to show it's not. Okay, it's always reverse onus, or not always, but most of the time reverse onus when it comes to employer-employee relationships. You have all the ability to make these changes. You have all the ability to make this safe place to work. You're going to be expected to do that. You must regulate and inspect. You will need to show if somebody knocks on your door and says, hey, I have complaints or concerns, what you've done, what procedure you followed, what safeguards you put into place. You should take photos. If you put up plastic, take photos of you taking up plastic. You never know what happens. For some reason, it could be, could be a disgruntled employee, and then all of a sudden somebody comes in and WorkSafe's there and you don't have plastic up. You can say, look, this is what we did and we showed it up. And as of yesterday, I can say this is still the same. Create policies. Find a policy, and hopefully there are some coming from the government, but use HR, use the organization you're involved with, but create a policy that ensures that you are doing certain things to keep your employees safe. And again, I'm not a doctor and I'm not going to say I'm an expert on COVID-19, but I've heard a lot of these things. Get them, create them, make them policies. Those policies could improve checklists. So example might be is we have a checklist, and the person comes in the morning, they do this sanitization, and they've checked it and they've signed it. Okay, so we know that that's been done. I know some organizations say that, they stagger employees, but every morning somebody goes around, or actually I think it's 2 or 3 times a day, and they sanitize everybody's workstations, and they put a little thing that says, a little red card that says this one's been sanitized, but they also should be checking it and signing it. It's kind of like when you walked into a washroom, you see that thing, this was checked by this person at this point. Perfect example.
Dean, I'm just going to interject because we have 5 minutes left.
How much time? Whoa. Okay. Okay. Well, we're going to have to fine tune some of this. So there might be a part 3, guys. We'll see. Okay. Here's the biggest thing. Okay. I always try and tell you guys this. Here's one of the things you want to take. If you're going to do standards, which I recommend you do, make sure you don't go below those standards. That's the key. Okay. That's where businesses get hammered in court. So quick tip. Eli, do we have much questions or do we have any questions?
2 questions.
Okay, I'm gonna maybe take a little bit more than that 10 minutes, but at 5, you can shut me down, okay?
3 questions actually now.
Okay, so you should be able to show safety standards to the government level are consistent and monitored. That's the key, okay? You should have standards. You should put policies in place. That's what you should be doing. But if you put them in place and don't follow them, that's way worse, okay? You know what I'm going to do? I think I'm going to have to skip the privacy issues. I'm going to give you Cole's notes of that because there's something more important that I want to talk to you about that. People have a right to have the protection of privacy. You know what I'm going to do? Privacy is anything about person, and generally it's a record. So it could be an email, it could be a photograph, it could be their files. They have a right to that protection. And I'm going to skip right to, I'm going to skip right down to, actually, sorry, I didn't do it on here, but what I'm going to tell you, oops, I'm going to go back a little bit. Sorry, excuse me about that. Best practices. Okay, good. I'm going to tell you about best practices, and I don't have that as a quick tip. Best practices, don't tell anybody else in your employment, or anybody, your wife or your kids or your husband or whatever, anybody else's personal information, unless you have to, okay? That's your best practice. If you're doing it because it's convenient, or it'll explain why this person can't work with this person, not good enough. If someone comes to you and tells you they have COVID-19, it's not your business to tell someone else. If someone comes to you and says, I'm concerned because I don't have COVID-19, but I have breathing problems, or I'm diabetic, or I have HIV, do not tell anybody else that information. Even their supervisors. Think to yourself, can I just tell the supervisor, hey, this person doesn't have to do this and this. I don't need to tell them why. Fines for breach of Privacy Act is $10,000 up to $100,000 per corporation. I've done whole seminars just on this. I apologize, but I've got to give you the Cole's notes and the reels. Now, I'm almost finished. So best possible liabilities. This is for customers and the public. And it's very similar to what we talked about employees. So I'm going to give you where I think the genesis of where I talked about employees is. Let's say this is very similar to a situation where you walk into a grocery store and you slip on some water, you're walking through produce and you slip on some water and you hurt yourself. Well, you know, as a grocery store owner, you're liable for anybody that comes into your store. There's something called the Occupier's Liability Act. You're just liable for them. To what standard and to what degree, that's the key. As an employer, you're liable for all your employees. You're also liable for what your employee does. Okay, so on my slide here, if someone comes into your office property, you're responsible. If your employee harms them, you're most likely responsible. So similar to employee safety requirements, safe, consistent procedure that you can consistently adhere to. So let me give you an example. So someone walks in, slips on the water. The courts recognize it can't be perfect. You can't have a running open store with produce that sprays water on it without some water getting on the floor. They recognize that. Perfection is not the standard. What the standard is a reasonable procedure to protect people. And that's why I say, look at the government. The government's giving reasonable, and certainly if you go to court and you say, hey, I did what the government says, I think the courts are going to say, and again, I think, because this is unprecedented, I think they're going to say that's a reasonable standard. So then you have to put in a procedure that's, okay, we clean up the floor in the grocery store, we clean up water every 15 minutes. We have someone sign that they've done that. We use a mop. We put out a wet, floor sign. That's why you see those wet floor signs, because that's a procedure that somebody started that they have to do. If you have a situation where employees or clients can be harmed, use a procedure, and I'm talking just about COVID-19 here, that the government has given you, and then adhere to it. And that means that if someone's not doing it, you might have to discipline them. But you have to show you've done it, okay? That's it. You don't have an option. If you don't do that, you're going to be responsible, and you're probably going to lose either getting a fine from some government body or in court. All right, so I'm starting to wrap this up now. Safe work environment to government standards. Accommodate employees as much as possible. Ensure you can prove that you consistently adhere to government-approved procedures for customers and employees. Keep employees' information to yourself or limit as much as possible. Okay, so we've got questions. As I mentioned, we'll see what the good questions are. Eli, we want to flip to those questions.
Okay, yeah, so we got 3 questions so far. Question number 1, what duty does the employer have to ensure a safe environment for employees working from home? Or I guess these are kind of 2 questions in one, or rather best practices to ensure a safe work environment at home. Issues such as ergonomics, family commitments, domestic violence, etc.
Well, that's a very good question. You know what? I might have to take a pass on that one because I'm going to think about that. I will tell you that if you want someone to do something for you, so I'm not going to, don't know if I can answer this. You're responsible while they're doing it. Ergonomics, that's interesting. So I think you would be responsible to give them, if you're saying, okay, I want you to type out for 6 hours a day because you take out your breaks, you should give them something ergonomically. If they hurt themselves, carpal tunnel is a great example. You probably have to accommodate them in a way. So I don't know how much you have to do in the first instance. I think you should probably supply them with those things, especially if your employment contract doesn't say that they have to get their own monitors and they have to get their own computers. And in fact, as lawyers, we've offered that to our employees. We also make sure that they have separation of privacy because we have privacy issues for our clients. But I will say the other part, domestic violence, that was one I just not prepared to answer. I'll have to add that and then send that out to. It's a good question, and I don't want to give a quick answer in this unprecedented times. Mm-hmm. It's a good question, so I'll have to think about it. Okay.
Okay. Second, I guess, question number 2. I currently run a temp agency for the hospitality industry, and everybody on our roster have been hired under the position casual on call. Do we fall under the same rules as full-time or even part-time employees? Our employees choose their work schedules from what shifts we have available.
Well, you know what, I guess I don't know why I keep asking the questions, because here's the thing is that one of the issues are your employees or are they contractors? And those are multifaceted questions. So I think it sounds like you've set up some people to be contractors, and then Employment Standards Act has no applicability. But I will tell you that I've experienced many employers that think they've set up people as contractors, and they have not, because there's a criteria, and it's actually, Employment Standards has a test, and it's very similar to common law. And I'm not going to get into that today. So if they're contractors, they do not fall under, in fact, if there's contractors, then there's nothing but your employment contract. And so you'd have to see the employment contract. If you don't have an employment contract, then there's some implied terms, and I think those implied terms would be the level of service, the level of hours that they should be getting. Contractors are a different beast. We're talking about employees. So I'm not going to answer that question specifically. If they're employees, they have all the benefits that employees have. And if they're if they're contractors, they almost have none. You're just 2 equal parties that contract an agreement. I will say that if the question unfortunately wasn't really what part are you specifically asking for, but let me just say generally, if you're contractors, it's a very different beast. Because you set them up as contractors doesn't mean they're contractors. So I think you might need to get if you've had a legal opinion and they're contractors, then you're great. You have a whole different, then a lot of this is not applicable because this is applicable to employees. Oh, now we're getting some questions. So Eli, that's the best I can do with that question.
Sure. So I'm actually having a little bit of technical difficulties with my computer. So Dean, can I ask you to actually pull up the question window? I can't scroll down for some reason.
Do I have to do everything, Eli?
Apologize about that.
I can read them for you if you need, Dean.
I see Eli Zavar's on here, which is an employee of ours. Nice to see you, Eli.
Well, it's great to see another Eli.
Yeah, there's not too many of them. I'm not sure where's the top. Duties, okay, no, okay, I see where we are. Okay. Okay, so I've answered that one. Oh, okay. So on the question about the contractors, I think that's a very specific question. Let me just see if I can. It's a difficult question because the question is, do they follow the same rules as full-time or even part-time employees? It depends what rules you're talking about. I don't think people have the right to See, again, it depends on your employment. It depends on your employment contract. There's something called RPT, regular part-time, and those people have a set term on the contract of how many hours they can get. So I think that they would have some protections as far as hours and not hours. But I do, so I'd have to look at your contract to answer that question better, because that's really a specific. Do they fall under the same rules? Yes, some of them they do. They have a lot of protections. So if they're employees, they have a lot of protections. The main rule they wouldn't fall under is whether, what protections do they have for hours, and what protections do they have for being partially laid off? And again, that's very fact specific if there's a contract or not. So I can't answer that question probably to as much as you want, but that's probably the best I can give you right now. So, as far as severance, again, there's an RPT requirement of that. So if the question is regards to severance, yes, they do have protections. There's very specifics in there. There's a calculation as far as severance goes, but yes, they do get severance protections as employees.
Good. Okay.
I think that's kind of the end of the question. Let me just see. Okay, yes, I think I've answered the questions. And those are good questions. So we'll have to be sending out some USB 16 gig Davison Law Group. Thank you very much. That was good. And I do think we hit some high notes. And if we have some other ones, I think we'll go through like we did last time, Eli and Jim. And you can find this, I believe, on Fernandez Young's YouTube page. So I do appreciate the opportunity, Jim, and thank you all very much for listening.
Thank you, Dean.
If I may say something, Eli, before we finish, I want to thank Dean for his good presentation. It's been very informative, and the questions that we have been receiving during the week show the interest that you have created, Dean. So thank you for these last 2 weeks of presentations, and we will continue looking for your help in the future, in future presentations. Thank you again.
Yeah, I'd just also like to say thanks again, Dean, for giving us your time and excellent and very informative presentation.
Oh, no problem.
So let's wrap it up for today.
I just want to say unprecedented. So you have 3 more.
Was anybody out there keeping count? Might have some drinks to have this afternoon. So as always, fernandezyoung.com/COVID-19 kit. There you can find a summary of government benefits that's updated, that's up to date rather. You can also find a link to our YouTube channel where we're posting the recordings of all our webinars. And again, fernandezyoung.com and also dlg-law.ca for Dean Davison and Davison Law Group. So Dean, thanks for being with us. Jim, thank you for being with us as well. And
don't forget, Eli, sorry to interrupt you. Don't forget to announce SIA's presentation next week.
Right. Can you remind us of the topic for next week as well?
Yeah, we'll be with business management, how to improve the performance of your business. And that will be presented by Sia Kao, who presented a few weeks ago. And he will be another guest speaker for next week. Excellent.
Registration for that presentation next Friday, same time. The registration for that will be open very shortly. fernandezyoung.com/COVID-19. It's COVID-19 kit, excuse me. That's where you can register for it. Great. So we'll sign off for today. Thank you, everybody, and we hope to see you next week.
Thank you. Have a great day.